The Supreme Court will be taking up a gun rights case.
We have breaking news. The Supreme Court has made a decision on the first major Second Amendment case in decades.
The Supreme Court just issued an emergency order so consequential that it's reverberating through every courthouse in America, and most people have absolutely no idea it happened. This isn't a routine ruling that took months of deliberation and carefully scheduled arguments. This is the highest court in the land stepping in immediately because something so fundamentally wrong was happening that they couldn't wait for the normal glacial pace of justice. What they decided could completely restructure how constitutional rights, not just Second Amendment rights, but all constitutional protections, are treated when citizens challenge government restrictions. The implications are staggering, yet the story has been buried beneath the noise of daily headlines. Let me be direct about what makes this emergency order so extraordinary. It's the timing, the urgency, and the specific constitutional questions it raises about whether lower courts have been applying a dangerous double standard. Here's the principle that's supposed to be ironclad in American jurisprudence. When a federal judge determines that a law unconstitutionally violates your rights, that law should be blocked immediately while appeals move through the system. That's been the established standard for decades across virtually all constitutional challenges. It's how the system protects citizens from irreversible harm while legal questions get resolved. But something deeply troubling has been happening in federal appeals courts nationwide. These courts have been allowing gun restrictions to remain in force even after district judges explicitly ruled them unconstitutional. And they've been doing this at a rate that legal statisticians have documented as significantly higher than stays granted in First Amendment free speech cases or Fourth Amendment search and seizure cases. The data reveals a pattern that's difficult to dismiss as coincidence. This emergency order directly confronts whether appeals courts are systematically treating Second Amendment rights as second-class constitutional protections. Federal judges are bound by a rigorous four-part test before allowing an injunction to be paused. They must evaluate whether the state is likely to succeed on appeal, whether staying the injunction would cause irreparable harm to citizens, whether other parties would suffer harm, and whether a stay serves the broader public interest. This test exists precisely to prevent government from continuing to violate constitutional rights during the lengthy appeals process. What most people don't realize is that this emergency order could force a complete recalibration of how preliminary injunctions function in constitutional cases across the entire legal system, not just gun cases, but potentially affecting how courts handle challenges to speech restrictions, religious liberty violations, due process denials, and every other constitutional protection. The gun owners who brought this emergency request to the Supreme Court aren't challenging some obscure technical regulation buried in administrative code. They're fighting restrictions that were deliberately designed to make it nearly impossible to exercise constitutional rights in actual practice. After a landmark Supreme Court ruling established that Americans have a constitutional right to carry firearms for self-defense in public, several states responded with legislative maneuvers that effectively created carry-free zones covering almost all public spaces. These laws force permit holders to navigate a regulatory maze so Byzantine and complex that law-abiding citizens face potential felony charges for innocent mistakes, like accidentally stepping onto property where carry is prohibited without realizing the boundary line. A federal district judge carefully examined these restrictions and concluded they likely violated the Constitution because extensive historical evidence showed no tradition of such sweeping prohibitions on carrying arms in public spaces. The judge issued an injunction blocking enforcement of these provisions, but within mere days the state appealed and requested a stay of that injunction, and here's where the process broke down. The appeals court granted the stay without conducting the required rigorous analysis of irreparable harm or likelihood of success on appeal that federal law mandates. What's genuinely shocking about this is how cursory the appeals court's reasoning was. The stay order was only 3 pages long and cited almost no legal precedent explaining why enforcement of an unconstitutional law should continue. It was precisely this kind of superficial treatment, this rubber stamping of government requests to keep enforcing laws that district judges found unconstitutional, that prompted the Supreme Court's emergency intervention. This emergency order creates ripple effects that extend across the entire federal judiciary because appeals courts don't operate in isolation. Their decisions establish precedents that influence how district judges rule in similar cases throughout their entire circuit, which can encompass multiple states and tens of millions of people. Right now, there are at least 17 active Second Amendment cases in federal courts spanning 6 different circuits that involve nearly identical legal questions about carry restrictions, so-called sensitive place designations, and permit requirements that were enacted in direct response to recent Supreme Court guidance. What makes this particularly significant is that some of these other cases involve even more restrictive laws than the one in this emergency application. We're talking about regulations that require applicants to disclose their social media accounts for government review, submit to in-person interviews where they must explain and justify why they believe they need to carry a firearm for self-defense, and provide character references from people willing to vouch for their supposed need for protection. Think about that for a moment. Imagine having to convince government officials that you deserve to exercise a constitutional right, and having to persuade your friends and neighbors to write letters supporting your request. Federal judges in at least 4 of these cases have issued injunctions blocking enforcement after finding the requirements facially unconstitutional, but appeals courts paused those injunctions using the same questionable reasoning that just got checked by the Supreme Court's emergency order. What you might not fully appreciate is that this pattern, enacting restrictions, losing in district court, but then continuing enforcement anyway through appellate stays, has created what legal scholars are calling a constitutional crisis where rights exist on paper but not in practice for millions of Americans. States defending these restrictions have developed a remarkably sophisticated legal strategy that exploits the inherently slow pace of appellate litigation to maintain enforcement of laws even after they've been declared unconstitutional. Here's how it works. The moment a district judge issues an injunction, immediately file an appeal and request a stay, arguing that allowing the injunction to remain in effect would cause administrative chaos and grave public safety concerns. Then systematically drag out the actual appeal for 18 to 24 months or longer, while the restrictions remain fully enforced on the ground. During this extended period, citizens whose rights were found to be violated continue living under the unconstitutional regime. The emergency order fundamentally disrupts this strategy by signaling unmistakably that the Supreme Court is paying close attention to these procedural manipulations and will not tolerate appeals courts rubber-stamping government requests for stays without proper constitutional justification. Some legal scholars are noting that this could force states to actually litigate the substantive merits of their cases, rather than relying on procedural delays as their primary defensive tactic. Because if they can't obtain automatic stays from sympathetic appeals courts, injunctions will remain in effect, and citizens will be able to exercise their rights during the entire appeals process, which is exactly what's supposed to happen when a law is found unconstitutional. Interestingly, some states are already discussing legislative workarounds, different regulatory mechanisms that would technically comply with court orders while still achieving substantially similar restrictive outcomes through alternative legal structures. This cat-and-mouse game between legislatures and courts is likely to intensify. The immediate effect of this emergency order is that lower courts must fundamentally reconsider their approach to constitutional injunctions, but the long-term implications depend entirely on how appellate judges respond and whether they interpret this as a narrow procedural correction specific to one case or as a broader mandate about respecting all constitutional rights equally throughout the appeals process. Within the next 30 days, the appeals court in this specific case will need to issue a new decision addressing the stay request with significantly more rigorous constitutional analysis. Legal experts predict they'll either dissolve the stay entirely, allowing the district court's injunction to take effect, or create such strict conditions on continued enforcement that the practical effect will be nearly identical to an injunction. Either outcome represents a substantial victory for constitutional rights. Federal judges who previously felt constrained by circuit precedent that seemed to systematically favor granting stays in Second Amendment cases are now emboldened to keep their injunctions in place, knowing the Supreme Court has signaled clear support for protecting enumerated rights during the appellate process. Court watchers have identified at least 8 pending cases where district judges issued strong constitutional rulings, but then saw their carefully reasoned injunctions stayed on appeal. Those judges are reportedly considering sua sponte orders, meaning orders issued on their own initiative without a party requesting them, asking the appeals courts to reconsider their stays in light of the Supreme Court's emergency intervention. What remains genuinely uncertain is whether the Supreme Court will accept additional cases to provide more comprehensive guidance through traditional merits briefing and oral argument, or whether this emergency order represents their preferred approach of issuing targeted interventions that correct specific constitutional problems without establishing sweeping new precedents that might have unintended consequences in other areas of law. Here's what makes this emergency order potentially transformative beyond Second Amendment litigation. The principle at stake applies to every constitutional right. If appeals courts have been systematically treating one enumerated constitutional protection differently from others when it comes to preliminary injunctions, that's a profound equal treatment problem that threatens the entire constitutional structure. Free speech advocates are watching this development closely because similar patterns have emerged in some First Amendment cases, particularly involving controversial speech that governments claim creates public safety risks. Religious liberty cases have also seen instances where appeals courts seemed more willing to grant stays when the constitutional right at issue involved religious exercise rather than secular activity. The emergency order sends a clear message. Constitutional rights aren't hierarchical. The Bill of Rights doesn't contain first-class and second-class protections. When a federal judge determines that government has violated any constitutional right, the same rigorous standards must apply regardless of which specific right is at issue. This principle, if consistently enforced, could reshape constitutional litigation across every category of rights. There's a common misconception that procedure is boring legal minutiae, while substance is what really matters. But constitutional procedure is substance. If government can continue violating your rights for years while appeals slowly wind through the system, the fact that you might eventually win becomes almost meaningless. Rights delayed are rights denied. That's not just a slogan, it's a recognition that constitutional protections only have real meaning if they're actually enforceable in real time. This emergency order represents the Supreme Court acknowledging that procedural mechanisms have been weaponized to nullify substantive constitutional protections. By intervening at the preliminary injunction stage rather than waiting years for a final merits decision, the court is protecting the practical exercise of rights, not just their theoretical existence. For people who aren't lawyers or constitutional scholars, here's the bottom line. This emergency order matters because it's about whether constitutional rights are actually enforceable or just words on parchment. It's about whether government must immediately stop violating your rights when a federal judge says those rights are being infringed, or whether government can continue the violation indefinitely while appealing. It's about whether all constitutional rights receive equal respect from the judicial system, or whether some rights are systematically devalued. The emergency order suggests that the Supreme Court has recognized a dangerous pattern and intervened to correct it before it becomes irreversibly entrenched in federal jurisprudence. Whether this intervention will successfully recalibrate how lower courts approach constitutional injunctions remains to be seen. But make no mistake, this is one of the most significant procedural developments in constitutional litigation in years, and its effects will extend far beyond any single amendment or any single case. This is about the fundamental architecture of how constitutional rights are protected in America, and that affects every single person, regardless of their views on any particular issue.